Ms. Watkinson.
Thank you, my lord. I was asked before the short adjournment whether we disputed the definition of sign 2 as MMM. Having taken some instructions over lunch, the appellants do take the position that the sign as it appears in the judgment on the signboards, under paragraph 123, it does say MMM burger, and therefore we say that the sign could include the reference to burger rather than just MMM.
Could is unhelpful, does it or does it not? And also, while I'm speaking, let me ask the follow-up question: was this point taken before the judge?
Well, it wasn't, my lord. No.
Is it a bit late to take it now?
Well, yes, I appreciate that point. It's perhaps in hindsight, on reflection, a point that should have been taken at trial. But I just wanted to clarify that in response to your lordship's early question.
Well, given the point wasn't taken at trial, it follows that you have to apply for permission to raise it as a new point on appeal.
My lord, I mean, this point doesn't necessarily require an examination of evidence as such. It's there in front of the court to see MMM burger, and therefore we would apply for permission in that regard.
Well, I suggest that in the interim we consider on the basis that that's now an issue, but obviously we'll hear what Mr. Pearson has to say in opposition to your application to raise the point for the first time now. But later.
So turning to the final ground of appeal then, I think it's helpful to divide the ground into two parts. So firstly, we say that the finding of a likelihood of confusion between the triple M mark and sign 2 was rationally insupportable. Now, the judge's analysis on this point is at issues 7 to 9 of the judgment. This is at paragraphs 123 to 132 of the judgment, and that starts on page 89 of the bundle.
Well, as I understand your ground of appeal, subject to the new point you just raised, the ground of appeal is that she went wrong on issue 7. There's no independent attack upon her other conclusions. I mean, appreciate you say that if she went wrong on issue 7, then that has a consequence in terms of likelihood of confusion. Am I correct?
Yes.
There's no independent attack on the other.
That's correct, my lord. It's a case of the snowball effect, essentially. Having made what we say were incorrect findings in relation to issue 7, the judge subsequently made what we say was a wrong finding of infringement under section 10. Now, the judge holds at paragraph 126, which can be found at the top of page 90 of the bundle, that I accept the claimant's case that sign 2 would be perceived by both classes of average consumer as orally and conceptually identical to the triple M mark, although visually dissimilar. Now, the key point here is that given that sign 2 was used by both D6 and D7 on menu boards, which were displayed within the Metro stores themselves, it's submitted that the visual comparison is the most important consideration for the court here. And hence, we say that a finding of visual dissimilarity between the respective mark and sign alone should have been sufficient for the judge to make a finding of no likelihood of confusion between the two. But moreover, we say the finding of oral and conceptual similarity is just plainly wrong. Now, as to oral,
Sorry, can I take this in stages?
Yes, my
I
lord.
appreciate that the ultimate question is likelihood of confusion.
Yes, my lord.
And I've got your point. You say, in context, visual comparison is important. Is it your submission that the judge should have concluded that there was no similarity at all overall?
I mean, my lord, ultimately, we say that there was no oral or conceptual similarity. Now, in terms of visual, we're talking here about the two words triple, followed M, followed in comparison to three M.
As I'm sure you appreciate, the reason I asked the question is that if there's no similarity at all, then the question of likelihood of confusion doesn't arise. You only have to consider likelihood of confusion if you get over the threshold requirement of a similarity between the mark and the sign. Whereas, if there's even a low degree of similarity, then one is over the threshold question, and then you have to consider likelihood of confusion. So hence, my question, is it your submission that the judge should have concluded that there was no similarity at all and stopped there? Would you accept that there was some degree of similarity and therefore the judge was right to consider likelihood of confusion?
Yes, my lord, I mean, I accept that there's overlap between the respective mark and sign in that there's the letter M.
So you accept some degree of similarity,
yes, my
you
lord.
would say low.
Yes, my lord. I mean, I don't think I could deny that on the basis that there is an overlap of the letter M, but insofar as that could possibly lead to a likelihood of finding a likelihood of confusion is another point altogether. Now, as to the oral comparison of the respective mark and sign, we say sign 2 would be pronounced as either one long sound or M. And in any event, if sign 2 were pronounced orally by a consumer as triple M, then the infringing use here is not by the defendants themselves, but by the customers in the way they pronounce it. And as such, it cannot be a use of sign 2 in the course of business, in the course of trade by the defendants in relation.
I'm mystified by that. We're talking about the perception of the average consumer of the sign in question.
Yes, my lord.
This is the point of the oral comparison. So how the sign in question would be pronounced by the average consumer is a necessary part of the inquiry, isn't it?
Yes, my lord, but our starting position is that the average consumer would not pronounce sign 2 as triple M. And as I will come on to in the second part, my submissions.
Well, that I can understand. I quite understand the proposition. No, the average consumer would not pronounce sign 2 as triple M. You seemed to be making a submission. If they did, that would be relevant because that would mean there would be infringement by the consumer and not by any of the defendants, which is what I was struggling with.
Yes, my lord. Perhaps I could clarify the point. The point I was trying to make was that we accept that if a trader configures its sign or mark so as to be pronounced in a certain way, they can be held liable for infringement. However, the possibility that some people might pronounce sign 2 as triple M or triple M burger. As the judge suggested, we say was based wholly on speculation, on speculative submissions made by the claimant. There was no evidence before the court to support that finding.
Well, it's the judge using her ordinary experience. What's wrong with that? You're saying she was not entitled to make that finding absent positive evidence.
My lord, I wouldn't go as far as to say that. However, we say that, well, I'll come on to this in the second part of my of my submissions. The judge herself was contradictory on this point in the judgment. Her analysis of how the average consumer would orally pronounce sign 2 in the family of marks section of the judgment is in complete contrast to the findings she makes in relation to the likelihood of confusion. Perhaps it might be convenient for me to deal with that point now. At paragraph 89 of the judgment, so that's on page 78 of the bundle, the judge makes two key findings. So firstly, she states, in my judgment, the MMM in the Morley's red and white mark, found as it is in the context of a sentence forming the strapline, is likely to be seen, pronounced, and conceptually understood by the average consumer as one long sound, as the familiar expression of pleasure in something tasty. Triple M is a somewhat oblique reference to the MMM in the strapline of the Morley's red and white mark, which I am satisfied many consumers would miss. She then goes on to say, I am also satisfied that few, if any, consumers would look at the words triple M and read, pronounce, or understand it as Similarly, I am satisfied that few, if any, consumers would look at the strapline it tastes better and read or pronounce that as triple M, it tastes better. That seems to be extremely unlikely.
And then she goes on to say, but note I've reached a different view when MM was used in a different context. See the discussion in relation to issue 7 below. So the judge didn't think there was any contradiction.
Yeah, I appreciate that point, my lord. However, we would say that that's simply an incorrect finding. It's a rationally insupportable finding. The judge herself recognised the contradiction. That doesn't mean that it wasn't a contradiction.
Okay.
So just to compare that to the judge's finding and the judge's analysis of the sign 2 in the context of likelihood of confusion, the judge states at paragraph 126 of the judgment, so that's at the top of page 90 in the bundle, she says, I accept that sign 2 in the context of the name of a burger as distinguished from the use of MMM as a word within the sentence, within a sentence or strapline, as in the Morley's red and white mark, can naturally and easily be pronounced triple M. As in, I'll have a triple M burger, please. Yeah. So our submission is in both contexts. The in burger, or it tastes good, or whatever, it tastes better. These are both expressions, references to a culinary satisfaction.
It's a bit tricky. I mean, suppose you were using the menu card and you wanted to order the burger. You wouldn't say, I'd like an burger, would you?
My lord, I don't. I submit that there is no evidence to suggest otherwise. I concede that there's multiple ways in which sign 2 could potentially be pronounced orally. Triple M is not one of the ways in which we accept it would be pronounced orally by the average consumer. It's a possible way in which the sign could be pronounced, but we say it would not be pronounced in this way by the average consumer. And this point, we say, is made by the judge herself in the judgment. The contradiction in the findings of how the average consumer would refer to the sign MMM or we say the contradiction is not justified. There's nothing in the judgment in and of itself to explain why the difference in context between family of marks analysis and the likelihood of confusion analysis means that the average consumer would understand, would pronounce sign 2 differently in each context. There's no explanation of that in the judgment. And we say the judgment is contradictory in this respect. So, my lords, my lady, to conclude then, the appellants say that the finding of a likelihood of confusion between the triple M mark and sign 2 simply does not get off the ground. We say the marks are visually similar to a low degree in that they overlap the overlap in relation to the letter M. We say they are conceptually, orally and conceptually dissimilar, or there is no similarity. And the likelihood of confusion, the finding of a likelihood of confusion between the respective mark and sign was rationally insupportable. Unless my lords or my lady have any further questions for me, that concludes my submissions on the final ground of appeal.
Thank you very much, Ms. Watkinson. Ms. Pearson.
My lords, my lady, subject to the court, I propose to deal with, if I may, the principles to be applied on this kind of appeal, just very briefly, and then deal with the grounds in order, following the structure of my skeleton more or less, and subject to any questions or interventions. In terms of the principles to be applied on appeal, the majority of the grounds relate to the judge's conclusion on the likelihood of confusion. So grounds 1, 2, 3, and 4 in relation to sign 1, ground 8, as we've just heard, in relation to sign 2. Obviously enough, the assessment of the likelihood of confusion is arguably the most common multifactorial evaluation in trademark disputes. And it involved an analysis by the judge of a large number of evaluative processes. Now, I'm conscious that your lordships and your ladyship are well familiar with this particular test, so I hope you will indulge me a couple of minutes just to run through some of the factors that feed into the assessment of the likelihood of confusion. For example, analysing and evaluating the qualities of the claimant's mark. So that's the inherent distinctiveness, what elements are dominant, the roles played by each element towards its origin function, how it's been used, markets, channels, geographical reach, advertising, promotion, accolades. This goes to acquired distinctiveness. So there's evidence of history, historical use. That also goes to reputation, and you've seen in this case that the Morley's mark enjoys quite a strong reputation, particularly in South London. Then there's the comparison of the marks, which is a qualitative process, identifying and comparing the goods and services in relation to which the respective marks are used, identifying the average consumer, which I'll come on to in a moment. And I say that there is scope for analysing and evaluating evidence in relation to that. Analysing and evaluating the contexts in which the respective marks are used. Again, that's something I'll come on to. I say that the judge was entitled to take context into account as at the date of the trial. And I'll mention some of those contexts in context, if I may. Analysing and evaluating the evidence of actual confusion. Analysing and evaluating the type of likely confusion. Is it direct, indirect? What is the likelihood of association as part of the likelihood of confusion? The list goes on, and each process in my submission can be broken further into its own evaluative processes. So this is a binary decision. It's yes or no. But all of these elements feed into it. I've mentioned in my skeleton at paragraph 3. So this is tab 5. I don't propose to go any further than what I've cited in paragraphs 3 and 4 of my skeleton, but if I may just read some of the more opposite parts of those paragraphs. And the principles to be applied where the judge's findings involved a number of evaluative processes were explained by Lord Briggs and Kitchen, with whom Lord Hodge, Lord Hamblin and Lord Burroughs agreed in Lifestyle Equities and Amazon. There, Lord Justice Lewison was quoted from Phage UK Limited. And I cite this respectively. Appellate courts have been repeatedly warned by recent cases at the highest level not to interfere with findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. And there are some cases set out there. At the bottom of that main paragraph, there are 5 reasons for this approach. They're set out. And they are obviously very familiar to you lordships and your ladyship. The expertise of a trial judge in determining what facts are relevant to the legal issues to be decided and what those facts are if they're disputed. Number 2, the trial is not a dress rehearsal. It is the first and last night of the show. 3, duplication of the trial judge's rule on appeal is a disproportionate use of the limited resources of an appellate court and will seldom lead to a different outcome in an individual case. And 4, in making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. And 5thly, the atmosphere of the courtroom cannot in any event be recreated by reference to documents including transcripts of evidence. Thus, even if it were possible to duplicate the role of the trial judge, it cannot in practice be done. In relation to the whole sea of evidence, the judge's finding was effectively that the accumulation of the evidence demonstrated a concerted intent from KK to mimic the Morley's brand, from its signage to its product name, so it's a triple M burger, even to its store, Get Up, and I'll come to that later, and even to store locations, but that comes with a word of caution.
Explain to me, what's the relevance of that finding? Because trademark infringement is a tort of strict liability. it doesn't depend on the defendant's intent. The defendant can be found to infringe even if they're striving to avoid infringement.
There is, I intend to come to that in relation to context. I'm going to cite some authority that says that the intent can be relevant to the average consumer's perception. So if I may just put that to one side for the time being. I say it will become relevant in relation to ground 4. The fifth little Roman numeral I mentioned was the atmosphere of the courtroom. You'll have seen from the judgment that there was an apparent difficulty KK had dealing with difficult questions in cross-examination, as if he didn't understand simple English. In contrast, there was an apparent ease with which he was able to deal with the judge's questions, or questions from his own counsel, as if he did understand, bearing in mind that all his documents were in English, and he runs an English franchise business, and he didn't have an interpreter at the trial. There's also, as part of this atmosphere, his inexplicable refusal to accept indisputable facts. I'll come on to that as well. There were 2 occasions when he was presented with identical images. One was the triple M burger, which you can see on the fascia, and the other was a photograph of a woman enjoying a burger. And I'll take you to those when I come on to context, because they say a lot in relation to his intent on the atmosphere of the courtroom. And his untruthful evidence as to when he started his business. And this is set out in the judgment at paragraph 65. Finally, in relation to the test on appeal, I would just refer to Little Great Britain Limited and my Lord Justice Arnold's summary there. This is in paragraph 4 of my skeleton. It is common ground that insofar as the appeals challenge findings of fact made by the judge, this court is only entitled to intervene if those findings are rationally supportable, as Volpe and Volpe. Equally, it is common ground that insofar as the appeals challenge multifactorial evaluations by the judge, this court is only entitled to intervene if the judge erred in law or principle. The points arising from that are all of these evaluative processes interact and contribute to the judge's final conclusion on the likelihood of confusion. I would liken it to a music mixing table where the judge carries out a careful production of all the media inputs to create a single output, which is the binary conclusion. And that production is unique. It can't be recreated here. And the only way to recreate the output without playing all the instruments would be to start all over again. And importantly, adjusting one of those sliders, adjusting one of those inputs, does not render the output wrong. For example, we say that the average consumer, and I'll come on to this, would have paid a low degree of attention. But if that slider is increased to something between low and medium, so the medium-low description of the degree of attention, in my submission, there are too many other evaluative processes involved for this court to intervene in the judge's final conclusion on likelihood of confusion. It would not be enough to enable your lordships or ladyship to say that the judge's conclusion on likelihood of confusion was not cogent. Similarly, on any slight variation or slight differences you may have from the judge at trial in relation to visual comparisons or conceptual or oral comparisons, these again are sliders that are not enough to change the final outcome, and it should not be, in my submission, disturbed. So those, thank you for your indulgence on those points. On the grounds themselves, as I mentioned, grounds 1, 2, 3, 4, and 8 all concern inputs into this multifactorial evaluation performed by the judge. So they are the average consumer, the visual comparison, sign 1, conceptual comparison, sign 1, context, and the oral and conceptual comparison in relation to sign 2. On ground 1, I will probably lean on the judge's reasons as quite heavily because I'm responding to the appeal for the reasons stated by the judge in her judgment. So I will probably refer to those from time to time to support them and to invite your lordships and your ladyship to endorse them. The judge carried out a review of the relevant law in relation to average consumer at paragraphs 26 and 78 of the judgment. So that's pages 58 and 74. She effectively mentioned Lidl, Tesco, and London Taxi Corporation. My learned friend has referred to London Taxi Corporation, paragraph 20, but I'd like to just mention a couple of other paragraphs there. And it's in the authorities bundle at tab 9. Page 311. This is to do with the notion of averaging of consumers. I'm going to read from paragraph 31. I agree with Briggs J that the notion of an average consumer requires the court to consider any relevant class of consumers and not to average them. And I believe that conclusion to be consistent with the approach taken by this court in Interflora and Marks and Spencer. And then scrolling, going down a little bit in the page to paragraph 34. As with all issues in trademark law, the answer to disputed questions is normally provided by considering the purpose of a trademark, which broadly speaking is to operate as a guarantee of origin to those who purchase or use the product. In principle, therefore, in the absence of any authority cited to us, which is directly in point, I would consider that the term average consumer includes any class of consumer to whom the guarantee of origin is directed and who would be likely to rely on it, for example, in making a decision to buy or use the goods. I mentioned earlier that I would touch upon the value of evidence in relation to the average consumer. I appreciate that it's a notional concept, but the evidence can be linked to the average consumer's perception. And the authority I wanted to refer you to is the Little case, which is tab 18. My Lord Justice Arnold will be familiar with this one. I'm going to go to page 713. About halfway down paragraph 117 on page 713, it reads, the court or tribunal puts itself into the position of the average consumer, or of ordinary consumers of the relevant goods or service, and then decides the relevant issue. The fact that evidence is often unnecessary does not, however, mean that evidence where it is available is of no value. And Your Lordship mentions the Federal Court of Australia case Arnold Limited, in which it was stated that information is preferable to intuition. Paragraph 118 in relation to the evidence of shopping habits. When deciding issues such as likelihood of confusion, it can be of value for the court to receive evidence as to the shopping habits of consumers of the relevant goods or services, for example, as to whether they are in the habit of reading the label on an item before selecting it for purchase, or whether they simply rely upon the appearance of the packaging. This is not in itself evidence of confusion, but it may be evidence of circumstances giving rise to a likelihood of confusion. In some circumstances, evidence of this nature can properly be given by means of factual evidence from a witness with experience in the relevant trade. Finally, paragraph 120. some points in his submissions, counsel for Tesco came close to submitting that evidence of this nature was irrelevant and therefore inadmissible because no single real customer could stand proxy for the average consumer in a trademark case or for ordinary consumers in a passing off case. When asked if he was really submitting that such evidence was inadmissible, however, counsel for Tesco retreated and accepted that it was admissible. He was right to do so. Such evidence is relevant not because the real consumers involved stand proxy for the average consumer or for ordinary consumers, but because the evidence may assist the court to gauge the perceptions of the average consumer or ordinary consumers. I mention this because the judge made reference to who were Morley's actual customers and used that as a base from which she could identify the average consumer. And in my submission, she's entitled to do that because these principles or these dicta here extend themselves in my submission to who is the average consumer. Her review of the evidence and submissions is at page 74, paragraph 74. Before I even start with that, it stands to reason that a fried chicken shop that stays open late at night and sometimes into the early morning is going to have customers who are tired, possibly in a hurry.
Possibly what, sorry?
Possibly in a hurry.
Yes, I see.
Fast food. The flu is in the name.
Yes. Well, quite. And particularly young people who come in groups, horsing around, they're not necessarily going to be paying that much attention to where they enter. They see the lights, they see the signage, that's a Morley's, and off they go. So the review of the evidence...
Why are consumers who come at night different to consumers who come in the middle of the day? Same person can come in the middle of the day, on another occasion can come late at night.
It may well be that they're acting more slowly. They are not in so much of a hurry. They're not too tired. There's also the context element, which I'll come on to, in relation to the signage and how they look at night, the fascias with the lights, the backlight makes them look even more confusing. And other than that, I can't really say because I can't put myself in their position. You see there, paragraph 74 to 77, the judge took time to review the evidence and submissions and the relevant law, paragraph 78. And in my submission, she was perfectly entitled to find that there were two classes of average consumer. One class made up of children, young people, students and families who've had lunch at tea time and into the evening and have low disposable income. I'm reading from paragraph 79. They will choose a chicken fast food shop by convenience of location and shop front from an advert on the delivery website with a medium to low degree of attention. The second class of average consumer, paragraph 80, is the late night and early morning revelers described by SS who are likely tired, hungry, and a significant subset of which will be intoxicated. They will also choose by convenience of location, shop front, and what is open late, and in my judgment will pay a low degree of attention. Crucially, there are two things that I'd like to say about that. One is that the judge is describing the degree of attention as low in relation to a class of average consumer which only includes the intoxicated consumer. She does not rely on that as the sole class on which she bases her assessment of likelihood of confusion. The second point I'd like to make is that the suggestion that there is some kind of salami slicing into multiple subdivisions is, in my submission, artificial. It doesn't come out of the judgment at paragraph 80. It is possible always to just break something down into as many pieces as you can think of, but it certainly doesn't isn't consistent with the judge's findings at paragraph 80.
She definitely deals in two classes, doesn't
Yes.
she? To that extent, there is a slicing.
Or sliced in two. There's a difference from taking a salami into multiple slices. It's a nice soundbite, but it doesn't work in my submission. And in particular, the judge in my submission was entitled to accept, we're calling him SS. SS is evidence that there was a spike of activity across all Morley stores around lunchtime, tea time, and then once again later at night. And for some stores with a later license into the early hours, the night and particularly late night customers are often impaired by alcohol. Now that, in my submission, is evidence that can properly be taken into account to help the judge establish the perception of our first or second class of average consumer. I have a note to go to paragraph 111 of the judgment. Oh, it's the same point. It's a subset. It's not the whole of the class who will pay a low degree of attention. In my submission, she was entitled to make that finding. It's not wrong or rationally insupportable. And there is no flaw in her evaluative process, meaning that she was entitled to conclude that this class of average consumer would choose by convenience of location, shopfront, what is open late, and in particular will pay a low degree of attention. If your lordships or your ladyship are against me on that and wish to move the slider upwards to medium low, in my submission that still won't make any difference to the outcome because that average consumer is still going to be confused. But there's no reason in my submission why that slider should move. Unless there are any questions, those are my submissions in relation to ground 1, average consumer. Ground 2, we say that the judge correctly reviewed the law. This is the visual comparison of the sign 1 with Morley's mark, the red and white mark. Again, it's another of the inputs into this famous multifactorial evaluation of the likelihood of confusion. And obviously, in itself, involves a number of evaluative processes, meaning, and I hesitate to say it again, the court should be reluctant to interfere. The review of the law is essentially the same. This is at paragraphs 27 and 78, just for reference. I needn't probably go there, and you've already seen it. And the review of the evidence and submissions in relation to this, and my learned friend has already taken to those, is at 93 to 95. That's where the claimant submissions are set out in relation to the visual comparison. And the defendant submissions are set out. And then at 96, there is a determination accepting the claimant submissions and establishing that the marks are quite similar. similar to a medium degree. There was during, in fact, in my own friend's skeleton and during submissions, a criticism in relation to the finding of the judge as regards the letter M at the start of the Morley's mark. There was a suggestion that there was a tension or contradiction between what she said in relation to the family of marks and then what she said in relation to the red and white mark. I've tried to debunk that in my skeleton in paragraph 15. She found at paragraph 88 of the judgment that the common element of the stylized letter M in the Morley's mark and the Morley's red and white mark is a distinctive form of the letter M present in both marks. And then at paragraph 87, she found that the letter M is not sufficiently distinctive as an element itself, being merely a single letter related to the general letter M. That's in relation to its presence in all three of the claimant's marks. So that's in the stylized version, in the Morley's mark, and the Morley's red and white mark, and as a plain letter in the triple M mark. So my submission, there are two different things. There's no tension or contradiction there. And that's something that you can lay to rest in a submission. I stand by the judge's reasons and her conclusion in relation to the comparison of the marks visually, and in my submission, unless there is anything else you wish me to address, there's nothing more to be said on that except it's not wrong. There's no reason why that should be considered wrong. Ground 3, conceptual comparison. Once again, this forms one of the inputs into our mixing table and the multifactorial evaluation of the likelihood of confusion. The criticism here is that the judge at one point made a selective evaluation of factors in her comparison and as to the weight she placed on various elements, particularly in relation to the strap line. If I could take your lordships and your ladyship to paragraph 93, Roman 4, on page 79. Actually, it's 80. You'll see there that she took into account all the elements of the strap lines, and all the shared elements. It wasn't selective. She didn't focus on any one. The use of a similar strap line with shared elements, taste, and an ellipsis, that's particularly, and conveying a highly similar concept of good taste. It's the real taste in sign 1, and tastes better in the Morley's red and white mark. It submits that on a global comparison, the signs are highly similar. So this was accepted as a submission. I would echo your lordship, Lord Justice Newey's remarks earlier that those two strap lines are essentially saying the same thing. It's to do with authenticity and quality. They are very similar conceptually. We've already seen how similar they are when how they look on the sign, and they contain these shared elements. So at a glance, you're hit with this visual effect of things that you're familiar with from the Morley's red and white mark. And it's not right in my submission to simply dismiss the strapline by saying, well, it's descriptive. Well, it's not. It doesn't describe anything to do with the mark or the food, goods and services for which it's registered. It's a...
Why not? I don't get that. Taste is surely a paradigm quality of food. Drink come to that.
Well, it evokes, as I've said in my skeleton, a feeling of anticipation of the taste of the claimant's products. So it's, it's a trigger for the response. And
If I say that
it's a
food
call to action.
tastes good, why is that not a description of the food? I don't get it.
Well, it doesn't describe the food itself. It makes a fanciful reference to what's coming out, or what you've just eaten.
Well, I could take the point that it's laudatory, but does that make any difference?
Laudatory can apply to very many things. It's not directly descriptive. It doesn't say this chicken tastes good, or you're going to love your burger. It's a little bit more direct. It's a call to action in a way. And in my submission, there's no reason why I should be given any downgrade in significance. I know my learned friend was at pains to say, well, look, nobody takes any notice of slogans, but McDonald's would say differently with "I'm loving it." Everybody's familiar with that, and it has an effect. And in my submission, the judge saw that as well with a measure of caution. So if you look at paragraph 97, she recognizes that the strapline is not dominant, but it's no means negligible. So she's not placing very significant weight on it, but she's not discounting it as something that has no significance whatsoever. It's an important secondary element which has a distinctive role independent of the dominant element. That must be right in my submission. So her conclusion as to similarity to a medium degree doesn't have any error of law or principle, is cogent, and was a conclusion she was entitled to reach. In relation to ground 4, I promised I would mention something about context.
Ground 4 wasn't pressed.
I do realise that, but it would be something I would like to take a bit further, if I may, because context had played an important part in all this.
But I'm puzzled by that. I mean,
Yes.
the normal reason why context of use is relevant in an infringement case is because it's relied on by the defendant to try to get out from underneath an apparent likelihood of confusion on the basis of a bare comparison of mark and sign. So the defendant says, well, yes, if you compared them in the abstract, there might be confusion, but that's not the right comparison. The right comparison is contextual, and in context, nobody would be confused. Can you point to any case in which context of use has been led to a finding of a likelihood of confusion where, absent that context, there would not have been a finding of a likelihood?
Yes, I might be able to assist with that. The Specsavers case had an element of that.
All right.
It's tab 3 in the authorities bundle. Just looking at the head note on page 29, paragraph page 14. assessing likelihood of confusion arising from the use of the sign, the court had to consider the matter from the perspective of the average consumer of the goods and services in question, and had to take into account all the circumstances of that use that were likely to operate in that average consumer's mind, in considering the sign and the impression it was likely to make on that consumer. The sign was not to be considered stripped of its context. The judge had approached the issue on the likelihood of confusion arising from the use of the strap lines entirely correctly. The average consumer would see the sign Specsaver and Specsavings in the context of the strap lines, and indeed the posters and other materials on which they were used as a whole. So the reference there is, that's Lord Justice Kitchen at paragraphs 87 to 88 in that Specsavers. I've just read from the headnote only. In fact, they don't say very much more than what I've just read out. That's on page 51.
And was this a case where confusion was found or not?
Yes, confusion was
Yes,
found.
I see.
So you can see there that, I mean, without going into the ins and outs of it, there were elements of context that were taken into account in assessing the likelihood of confusion.
Sorry, this is incorrect. When you look at the submission of paragraph 77, the judge had found no likelihood of confusion, and the submission that was rejected is that if he'd approached the matters correctly, he would have found a likelihood of confusion.
77? Arnold?
Mm-hmm.
My answer to that is that in lifestyle equities, this is the Berkshire Polo Club one, which is tab 19. Page 745. And this is quoting Justice Kitchen in Specsavers, that very paragraph that I cited, paragraph 87. It says the same principles are applicable when considering infringement, but it's necessary for this purpose to consider the actual use of the sign complained of in the context in which the sign has been used. As Kitchen LJ put it in Specsavers, in my judgment, the general position is now clear. In assessing the likelihood of confusion arising from the use of the sign, the court must consider the matter from the perspective of the average consumer of the goods or services in question, and must take into account all the circumstances of that use that are
Yeah, but the relevant passage where this issue is discussed is paragraphs 51 and following. And what I was saying earlier is what I said at paragraph 54.
Yes. It doesn't preclude the use of context in relation to a finding of likelihood of confusion, however.
So, I'm not suggesting at the moment, I would have to think about it,
Yes.
whether it is theoretically possible for context to increase likelihood of confusion. The question is has it ever had that effect? Because as I said in Lifestyle at 54, when you look at the cases, it's usually being relied on by defendants.
I understand.
Where absent context, they would lose.
Yes. What I'm doing is extending that principle to
All right, you say what sauce for the goose is sauce for the gander.
in so many words.
All right.
Right. And the reason why I'm keen to make that point is in relation to it's because of the various elements that make up the context. And if I could invite your lordships and your ladyship to look at the supplementary bundle, tab 5, which we've seen several times. So tab 5 and tab 6 together, that's the Morley's fascia. Metro's fascia. You see that the burger is identical. It's not just the same construction of burger. That's the famous Triple M burger, by the way. It's not just similar in construction. It's the same picture. It's the same photograph.
Well, fine. In which case, you would have a claim for copyright infringement in photograph. What's that got to do with trademark infringement?
I'm building a picture of context. I'm going to.
It's not part of the trademark. Your registration does not include a photograph of a burger. So how is that relevant?
I'm saying that if your lordships and your ladyship are with me in relation to the extension of context to the test of likelihood of confusion, then these are all elements that will weigh upon the perception of the average consumer. So, for example, this is the final one. I won't go through them all. Tabs 10 and 11. So the tab 10 is the Morley's counter and store get-up. And tab 11 is the Metros. So this is the context in which you see the signboard, you see the fascia, you're standing in front of the shop, and you see that inside through the window. That is bound to act on the perception of our average consumer. In looking at the signboard and determining that that's a Morley's and I'll go in and get some chicken or a burger.
Hang on, sorry, signboard. Which do you mean by the sign?
Oh, sorry, I mean the fascia.
Yes, that's it.
So you're standing
on
at,
the front of the counter.
yes, you're outside the shop.
No. Oh, sorry, I'm in the wrong. I'd moved on to 10 and 11.
10 and 11 is they're the correct pictures I wanted to refer to in relation to what you see when you're inside the shop.
So we're on the fascia.
Imagine you're outside the shop and you're standing in front of the fascia and you see what you think is Morley's and you look down and you see through the window what looks like a Morley's. That's important context in my submission.
Well, doesn't this not simply explain why ground 4 of the appeal is not pressed? Because what you've shown us is there's nothing in the context to disabuse the consumer who is likely to be confused. That's far I'm with you. But if your proposition is that even if they would not otherwise be confused, this gets you home, that's where I start to have difficulties.
I'll move on to the agreement and the question of consent. So it was a peculiar point. This is the cart before the horse point, but it's being said that the judge was wrong not to consider the annex.
Yeah, well, again, that wasn't pressed.
Yes, thank you. Put simply, this is a compromise agreement. It's not a license. It's an agreement between Morley's and an individual. It's a personal agreement. Morley's wants him to stop, and his friend, to stop doing what they're doing. That's it. I know that the appellants wish to turn it into something else, But in my submission, that's precluded by the third-party rights exclusion clause. It's precluded by the rest of the wording of the agreement.
When you say it's not a license, it does license KK to use the sign, doesn't it?
It's not a license to him of anything. It's just an agreement that he can use this particular sign. And on that, I know that, my lady, you mentioned earlier that, well, Annex A must mean that that's the sign the parties agreed.
Sorry to interrupt you, but what's the distinction you're drawing there? You say it's not a license, it's just an agreement that you can use this particular sign. What's the difference?
It's a release saying that we won't sue you if you use this sign.
Well, it says in clause 5.8, KK will be permitted to use. That doesn't say we won't sue you, it says you're permitted to use it.
That could potentially feed into the point I was making just now. My lady mentioned earlier, said, Annex A, sorry, is the sign that everybody agreed is not confusing. On my submission, that's not at all the case. It's not at all the case. This is a compromise agreement where one party is at pains to have to tolerate the use by someone of something they don't like, that they think is potentially treading on their toes. And in any good compromise, I'm not saying the wording of the agreement is excellent, but in any good compromise, both parties walk away not particularly delighted. This sign in Annex A does not symbolize a sign which is not infringing. That's all
But
I'm
the
saying.
very fact that it might be thought to be infringing suggests you do need a license, and that surely is what's conferred by 5.8.
Well, in my submission, it's simply the wording of the agreement. It's not an express license saying we own rights in this and you are now licensed to use it.
Sorry, are you saying that the agreement doesn't take a position on whether Annex A would otherwise be, use of Annex A would otherwise be infringing? I didn't quite
It doesn't.
follow.
Your ladyship is right. There is no position in the agreement. It doesn't
So
say
it's not it's neutral.
yes.
But just to go back to my lord's point, 5.8 permits KK to use it. So let's say it was infringing. Would that have to be regarded as a license?
Yes. Yes.
I mean, obviously, then they're not agreeing one way or another about whether it's actually infringing.
That's important. They are not.
So they couldn't
They're
really.
not. So it's then someone may take a view as to whether it's infringing or not. But certainly it's not something that's embodied in the agreement. There's no recital saying the parties having agreed that the sign in Annex A is not infringing. The claimant, the Morley's red and white mark, and so on and so forth. That's not in the agreement.
And equally, this dispute isn't strictly about whether the sign that appears in Annex A is or not infringing.
No, not at all. It was something that Metros were using and KK was
Signs 1
using.
and 2.
Yes, yes. Certainly, the analysis the judge went through was very methodical, and her reasoning is at paragraph 120, which is at page 87. This is to do with the point whether the other 7 defendants can rely on this agreement. In my submission, this is very nicely done. She does refer to all the elements of the agreement that close the door to the concept that any of the other 7 defendants can rely on it. In particular, she refers to the Rights of Third Parties Act clause 11, that's at 122. In relation to clause 5.6, which the Lordships and your Ladyship discussed with my learned friend earlier. My lady, your point earlier about 5.6 referring only to people who were using the mark at that time is opposite. That's, in my submission, the correct way to read that agreement.
I mean, is it fair to say that clause 5.6 contemplates that at least one third party will be permitted to use the sign?
Why, if I may ask that?
Because it says that KK has to procure any third party using the signs to use in the course of the trade metro signs. It sounds as though the idea is that anyone who is using the sign should now use the metro sign.
Well, the evidence from SS was that there was only one other person, so this is for that reason.
Fine, let's suppose it's one person. So the idea is that the one person is to be permitted to use the sign. Now, as you say, that one person is not a party to this agreement, so he can't get his right to use the sign from this agreement. Presumably it would have to come from KK.
Let me just... That may be so, but it doesn't expressly or impliedly extend to anyone else.
But it might be said that to that extent it must be contemplated that KK can license a third party, which might be thought to cast light on the meaning of use in clause 5.8, because on that thesis, the use would have to extend to licensing that particular third party.
Well, if we're talking about implied terms here.
Or I'm not at the moment, I'm talking about construction.
Well, I stand by the point that it's a personal agreement, and reading it strictly in that sense, there's nothing stopping KK and Amin from using the sign in Annex A for themselves. The intention of the agreement was not to extend that to a licensing franchise network. It was only intended to be a compromise agreement to resolve a dispute about the Morley's infringing brand. I mean, it has to be borne in mind the judge's conclusions on KK and how he was deliberately trying to get as close as possible to
how is that relevant to the
Morley's
interpretation of the agreement? Surely it has to be objectively interpreted according to the meaning the words convey to the reasonable reader.
In any event, it's my submission that even if you're against me on that, and that somehow the other 7 defendants can get in on this, it doesn't assist the appellants because of the problem with reasonable modifications. And if I say again that this is a compromise agreement where one party is trying to resolve a problem of someone else copycatting their brand, they're going to be at pains to agree something which is still vaguely similar, and the jury's out on whether that's confusingly similar or not. So evidently, it's much more logical to say that any modification that brings that sign closer to the claimant's mark is going to be a very controversial move. And it, in my submission, it makes a lot more sense to say that reasonable modifications do not include modifications that do that. And let's face it, there is an infinite number of modifications you can make to this. My learned friend mentioned adding a globe in the background. You can add whatever you like. You can change anything. It's why would you modify it to add things that bring it even closer? It's not reasonable from any perspective. And as regards the comparison of Annex A with the sign 1, again, in my submission, the judge carried out a multifactorial evaluation. She didn't slip up in her approach, and her reasoning in my submission is correct, and her conclusion was correct. And ground 7, breach of contract, more or less stands and falls with the likelihood of confusion point. Ground 8. If it's possible to say triple M when you look at the 3 M's together, then that is therefore conceptual and oral identity, making the marks highly similar in my submission. So that's, there's nothing more to be said in relation to that. It's in relation to burgers, so the goods are identical. And in relation to my learned friend's application, I'm sorry to say that we don't consent to it. The trial was a long time coming, and a change in position like this would feed into the evidence and submissions at trial. I'm not suggesting we'd have to have the trial again, but it is, I'm afraid, too late in my submission. And nothing has been tabled as to what that would look like.
Well, does it really make any difference? I mean,
let me answer that
say
question.
that it makes any difference to the evidence, does it? I mean, I appreciate that it undermines the judge's evaluation, because if the point is correct, then the judge's evaluation has been carried out on an incorrect basis. Now, you might say, well, it doesn't make any difference to the end result. But in terms of whether we should consider the point at all, or are you prejudiced?
Well, the trial is done, and we're here on appeal on different points. I accept that there's an appeal in relation to the comparison of the marks as accepted at trial. If it were to change the outcome, then that would be a prejudice to us, and I wouldn't want that to be a risk. We say it doesn't make any difference anyway, because the word burger is so low in trademark significance that...
Well, no. The fact that the new point is allowed in doesn't require you to accept that it's correct. So, question 1, should they be allowed to argue it at all? And that's a question of, are you prejudiced by the fact that it wasn't argued at trial? Question 2, if they're allowed to argue it at all, is the new point correct? Namely, is the sign properly to be taken to be triple M burger, for want of a better way of articulating it, or is it to be taken as triple M on its own? And even if the viewpoint is allowed in, it's perfectly open to you to say it's wrong, in which case, even if it comes in, we don't go any further. And then question 3 is, well, if the new point is correct, does it make any difference to the assessment of likelihood of confusion?
It's too late, it's wrong, and doesn't make any difference to the likelihood of confusion.
All right.
I mean, just on the first point, is
Forgive me, that's
that's would you have been any better off at trial if the point had been taken then rather than now? Now, presumably, you wouldn't have called any different evidence, and you wouldn't presumably have asked any different questions in cross-examination.
that's probably correct. So in terms of prejudice, it's only in relation to any inherent risk that it might actually change the outcome.
I see that, but I'm not sure that's relevant prejudice. I mean, we don't normally say the argument might be a good one, therefore you can't run it. Yeah.
In terms of procedural prejudice, it's slight, if any.
Yes, I see.
It would appear I've come to the end of my submissions, unless your lordships or your ladyship would like to ask me anything.
No, thank you very much, Mr. Pearson. Mr. Malovich.
My lady, just to take things slightly out of order, I'll respond on the last point just because it's fresh in your mind. No prejudice and presents a better case. It's a pure matter of perception. The judge showed a signboard showing the sign, and the sign was MMM Burger. That's the sign. It was distinct from the other signs around it. It might be said that it has a distinctive and non-distinctive part, but nonetheless, the identification of the sign is clear. The significance of it is that when it came to the judge's assessment in the family of marks, in the context of a longer statement, it tastes good. The judge thought that completely obscured the likelihood of somebody saying triple, because it's a clear expression of delectation, delight, whatever. We say, when used as a sign by the trader on that signboard, exactly the same thing applies. Burger. That's exactly what it's intended to be. It is an expression of delight. The other reason why they're unlikely to say triple, of course, is because the expression of delight could have 2, 3, 5 M's, and it isn't particularly associated with having 3 M's. So it's just simply likely to be seen as an expression in that sense. Now, we accept, of course, that there is a possibility, a theoretical, speculative possibility, that some consumers might, as Justice Arnold just did, for want of a better word said, they might refer to us as triple M. We say that has been conditioned by association with this case, and that, of course, if you'll forgive me, but that is not likely to be a consumer in practice.
I mean, they can only...
M-burger. M-burger could be...
I said it could be an M-burger. I mean, otherwise, no one's going to say burger, I think.
No, they're probably
might
not going to say that.
MMM burger,
But
or they might possibly say triple M
but the
burger.
sign being used has that look. That's the point, and that's the distinction between the trader and the consumer. It hasn't been designed or to lead to this rather, we say, quite remote possibility that some may identify the number and then triple it in order to...
Can you point to any authority in support of the proposition that the trader's intention as to how the sign will be perceived is material? It's an objective assessment of how the consumer will actually perceive the sign,
Ultimately,
regardless of what the trader may have intended.
Ultimately, it is, my lord, and but evidence of intention may be relevant on this. If they've, for example, if they had put capital M and then some small m's, maybe that might lead to more likelihood of people saying it's M rather than triple M. That may be a way, but it's difficult for me to answer that question. We say that the judge's the judge regarded it as very clear in the family of Marx context that when you put it in the slogan, followed by an ellipsis, so it wasn't even connected to the slogan, that would be seen as But in this context, not that we say is it's a small part of the case. I don't want to dwell on it too long. If I could just reply on some of the major points. The first and most important point I think my learned friend started with, of course, was the appellate principle, and we take no issue with that, although I think you probably sensed that during my submissions it was often, it was not always easy for me to know whether I was talking about a finding of fact that I was challenging or a multifactorial assessment. I think probably on balance most of them were multifactorial assessments rather than findings of fact, with the overall conclusion being the rational and supportable. But I leave that to my lawyers as to that. So far as the my learned friend very interestingly and colourfully characterised the various factors that need to be taken into account in a trademark case. I must remember to use this in my next trademark case. The like a DJ's deck with the slider buttons. And it was suggested that if I managed to move one a notch or two to the left, it wouldn't matter because the sound would still be blaring out the speaker in the same way, which I think is where we sort of getting to. The problem with that, of course, is that the average consumer is kind of the equivalent of the master switch or the master volume, because all questions are assessed from the vantage point of the average consumer, and that is the determining factor. And if one has taken a wrong approach with the average consumer, one has set the bar too low or set the bar too high, that vitiates the whole decision and makes it unreliable as in terms of its overall assessment, and makes it one that is more likely that the appeal court should be reaching its own view on, if it were to allow the appeal. So we say, for example, if you have things like the degree of acquired distinctive characters, my learned friend exhaustively went through the various factors. Context even might be a bit of a helping hand, or a helping hand for me. And I think my Lord Justice Arnold is quite right that we don't rely particularly on context. Where we were attacking the judgment was on the basis that this incriminating context was somehow enhanced the case. But let me just deal with I think probably the key point made by my learned friend in his submissions, which was that the judge was entitled to rely on the evidence in a case about the average consumer. That proposition is probably correct so far as it goes. I say probably because nothing is clear. But yes, we say probably correct that you're entitled to rely on evidence for the purposes of identifying the average consumer. But the problem is, in this case, the evidence did not support the judge's factual finding at all. It did not. There was no evidence for the finding that the judge reached about the attributes of the average consumer. I say that because we accept that there can be classes of consumer, we accept that the consumer's attributes can vary from case to case, and we accept that actually moving the slider from medium to low is actually unlikely to make that much of a difference, because that is not what we're talking about here. The learned friend said in terms that late night customers were impaired by alcohol. And the judge said that too. The only problem is, try as you might, you won't find any reference to that in SS's statement. He doesn't say impaired by alcohol. He simply says they've had a drink or they've been out drinking. There's a big difference between having a bit of a drink and horsing around inside a shop or whatever, and impairment. And we say impairment crosses the line. That is not an average consumer deemed to be reasonably careful and reasonably circumspect, which all notional constructs for all goods and services must be. And yet the judge not only said that specifically twice in the judgment, the first of them was paragraph 74, she said often impaired, often impaired. It's not just this is a sort of marginal thing that I'm not taking account of. This is often impaired in paragraph 74. Then at paragraph 80, she adds further attributes not mentioned by SS. They're tired, they're hungry. Well, tired. These are university age young people who've been out. I doubt very much they have to be up at 9 o'clock in the morning to go to work. They're probably not tired at all. They're about ready to go to the after party, one would have thought. And then the next thing she adds, of course, is hungry. Well, all consumers are hungry. All consumers of fast food are going to be hungry. Does that make them more or less careful? So the point is, it isn't about whether it's a low or medium to low level of attention. You could that's why those terms are somewhat meaningless. It's about whether the person who needs glasses was wearing the glasses. This was a consumer whose perception was impaired. And just to make it very, very clear, just for your note, I'll be as quick as I can. Paragraph 104, she returns to impairment, recording a submission from a learned friend, and then directly in paragraph 111, I took you to this in my opening submissions, paragraph 111, little Roman 1, the first factor determined this case on a likelihood of confusion from the perspective of an intoxicated person that she has described as intoxicated and impaired previously in the judgment. My submission, that cannot be a judgment that can stand. That is not a correct view of the average consumer, and that is not a slider on the deck amongst many, many sliders. That is a serious problem with the judgment. The on context. So this was the paradigm consumer. This was the notional construct that was adopted. It wasn't really even about whether, in reality, as my lady put it to me in my submissions, but surely some of these people, a large number of them, could well be drunk. Well, that's actually not the position, not relevant, unbelievably enough. You might be attracted to the idea that it should be relevant. Perhaps, for sort of Alcoholic Anonymous services, that would be reasonable, but for something like this, that is not an appropriate level of sort of appropriate set of attributes to attribute to the consumer, and there was no evidential basis for it. This was simply the judge's own colour added to a fairly bog standard, fairly simple statement by SS saying people had been out drinking. And in fact, it's in the context of a paragraph where he's talking about Morley's being a safe place for people to go. So it's more about they've been out drinking or nightclub or something, and it's a place where they can, if they're young women or whatever, they can feel safe and wait for a minicab to take home or something. So it isn't really even about people being intoxicated such to the point that their vision is impaired, which we say is really the only basis on which a judge properly informed by principle and case law would hold that these two marks are confusingly similar. I think I've probably said everything else I needed to say this morning.
Thank you very much. So we're not going to give judgment here and now. You will, of course, be supplied with the judgment in draft for you to correct our English and typing, but not so as to re-argue the case. We'd be grateful if at that stage you'd seek to agree in order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. I ought, even though I know you'll be well aware of it, to remind you of the importance attached to the embargo. Were you to think of anybody else who ought to see the judgment in draft, you obviously need to come back to us to get permission for that. Otherwise, it only remains to thank all of you very much for your very helpful submissions.